cases. The first tort case they want you to look at is the case of Garrett versus Daly. And I wrote guffaw, which means to laugh energetically, because this whole case is to help you connect the G's, guffaw, with Garrett. Because what happened was this woman, whose last name was Daly, Ruth Daly, she was going to sit in a lawn chair, a folding lawn chair, and there was a 5-year-old, last name Garrett, who moved the chair like to play a prank. And when Miss Daly went to sit down in it, she did in fact fall and break her hip, and sued the 5-year-old, Garrett. So his defense, it sets a precedent here for children and pranks, and also as far as proving intention in a tort case. What happened was uh, it went to court, and the defendant was found not liable because his lawyer argued that he did not intend for her to get hurt, and that it's proven because when he didn't think she would really move, she would really try to sit when he moved the chair, and when he saw that she had moved, he heroically tried to replace the chair. So she appealed the decision, and on appeal, went to the Supreme Court, and it was decided that the defendant was liable because even a child would know that harm could come when you move a chair out from underneath somebody. And so that is that set the precedent that intention is not only proven, that the person has to know, the defendant has to know exactly which harm is going to be caused. Even if the child just, or the defendant thought it would just cause embarrassment, um, if they know that it could happen, which a 5-year-old should know, then they could be found liable. So it establishes different types of intent. Doesn't have to prove that you know the specific action that will occur, but then you have to prove the knowledge that a 5-year-old should know that some sort of harm could cause, even if it's like embarrassment. Okay, then there was another case that was Kingston versus Chi. And for Chi, you can remember choo choo because it involves a railroad situation where the railroad, fire was sparked from somewhere by the railroad. It started growing. There was another fire somewhere else of unknown cause that also sparked and was growing, and the two fires combined to burn down property. Was the railroad company liable? Was the question. Liable. And so um, the precedent that this set was to go from the argument of but for to substantial cause. But for is argued when there is a direct cause and there's not multiple factors that cause the damage. The way that you test for whether or not you should use a substantial cause is, are there multiple factors? And then you have to prove that yes, it's one of the factors, and it is in fact substantial. For instance, if you had a big fire and somebody just strikes a match and throws it in there, that would not be a substantial factor because the fire was already raging. So at that point, they had to prove that while that fire might not have been the only fire, it was a substantial factor resulting in the harm to the property. So again, three things that have to be determined is number of causes and whether or not the defendant's influence, like, was that factor of the first fire that you know came from the railroad, was that substantial to have a strong effect. Another area you have to prove in substantial factors is lapse of time. If there's been a lapse of time, the defendant can argue that there were too many, it was too much time had passed, there were too much possibility for other factors, and say what else might have caused it to weaken the case and to not be held liable. Okay, so you can remember that again by choo choo chi. Kind of sounds like a sounds similar to help you link that in your brain. And then the last case we're looking at is Brisboy versus Fiberboard, and the name itself, Fiberboard's the name of a company that had products with asbestos uh, and asbestos fibers, so that can help you remember that. So a man is working, he starts working at Fiberboard, Brisboy. Brisboy starts working at Fiberboard for 1 to 6 months, develops cancer, and dies. The wife sues Fiberboard for damages. And um, they find out that the defendant smoked, well, not the defendant, but the plaintiff's husband who passed away, the decedent, is what he's called. He actually was a smoker. So then the question is, well, did the smoke kill him, give him cancer, or did the fiber give him cancer? So some considerations are, first of all, it's proven that it doesn't take much time of exposure to develop um, asbestosis, which can lead to cancer. So uh, the fact that he the decedent worked there for 6 months, it could only have required 1 month for the decedent to pass. Fiberboard was found liable, but the question that this attorney brought up is it didn't look like the defendant's attorneys did much research on what about all the other places where he worked. How do you know that he didn't come there with asbestosis? So it looks like perhaps that wasn't studied enough, and that one could argue that perhaps fiberboard is not, not a significant enough substantial factor.